Hi, I'm Claire Halle-Smith, and I work in the commercial department at Hassel. And today we're looking at access requests, subject access requests as they're known. Well, it's possibly the most used right under the General Data Protection Regulation, where a person can ask, well, any person can ask any company for a copy of their personal data throughout any time period. So although a company can then ask that person to limit the scope of their request to, say, a defined time or to a certain circumstance or event, that person's not obliged to do that. So once you've positively identified the person, you've got a month to send a response. So there could be an awful lot of data to go through, to review and collate and disclose within a relatively short time period. Well, it could be in any format. It could be received by email, it could be a telephone call, it could be made to anyone in the organisation. The person doesn't need to say they're exercising their rights, it doesn't need to mention the UK GDPR, and it doesn't have to mention anything about data protection. So essentially, if somebody contacts you and asks for a copy of their information or a copy of a document with their information in it, treat it as a subject access request. And then you can work out later on if it can be dealt with routinely. So there are a number of exemptions that you can apply to the disclosure, which means that you don't always have to disclose all the data that you have about a person, but these need to be considered really carefully. And one common one is third-party data. So if in disclosing the information to that person, you are then including information about another person, a third party, then you could be breaching their data protection rights by releasing that data. Now, all of these exemptions are available under the Data Protection Act. It doesn't mean that they can be applied as a blanket measure, but they would need to be looked at individually and documenting any decisions that you make as to whether or not you disclose that data. Occasionally you might get a request and you don't want to respond to it. You don't want to engage with that person for whatever reason. And there is the option where a request is manifestly unfounded or excessive for that request to be refused. But the Information Commissioner's Office, the Information Commissioner, the ICO, take a fairly strict view of using this. So it's not often available. If you as an organisation decide not to respond to a request, then you run the risk of being in breach of the GDPR, and that can attract the maximum penalty. A person who doesn't feel that they've received their response, a correct response or a full response, can complain to the ICO. And if they do that, that could result in an investigation of how you've processed that request. So many complaints don't result in a financial penalty, but the ICO will retain a copy of the complaint and details of the organisation, of your organisation, should any further complaints arise in the future. So practicalities in terms of what you can do: implement good housekeeping. Have as little data as you possibly can so that when a request comes in, you have less data to go through. Have an internal procedure that staff can follow so that they can escalate a request and it can be dealt with quickly and efficiently. And finally, keep a record of every decision you make. Document your decisions and the consideration you've given to the data protection laws, and so that you can evidence any decision you've made to the ICO if they decide to investigate in any future case. The General Data Protection Regulation and the Data Protection Act are the data protection laws that we need to be mindful of in the UK. And they will apply to you whatever type of business you're running, whether you're a new business just starting up or whether you're well established. The likelihood is that you're going to be processing personal data, in which case you need to be compliant with the law. Will really depend on the nature of your business and the amount of data and type of data that you're processing. So, are you a business just dealing with business contacts, or are you a consumer-facing business? Do you process data for children? Do you have CCTV on your premises? Do you carry out marketing? What sort of marketing do you carry out? So all of these questions are relevant when you're considering a data compliance programme. The extent of any compliance programme will again depend on the nature of the business. Probably a good starting point is to take a risk-based approach. So look at the type of processing that you're undertaking, look at the risks associated with that process, and try and mitigate those higher risks to begin with. And a really good starting point for that is to create a privacy policy, which you would display on your website, and you would make available to the people whose data you're processing. In order to put a privacy policy together, you really need to undertake a data mapping program, a data mapping exercise. So look at all the different types of data that are being processed by the business and what is happening to that data during the course of its time with the business. And then that will inform your privacy policy. So the different things that need to be included in a privacy policy will be the categories of data that you're collecting, how you're collecting it, what you're using it for, how long you're keeping the data, who you're sharing it with. You'd need to let people know if you're transferring the data outside the UK or outside of Europe. And if you are, then what safeguards will apply to that data? What security measures do you have in place for that data? And also you need to inform people what their rights are under the law. So it could be that they have a right of access to their data, or they have the right to rectify it, and all of the other rights that are available. It needs to be formatted in such a way that it's easy to read and it's easy to navigate. So consider the audience that the privacy policy is set up for. So if you're dealing with business contacts, you can use business language. If you're dealing with consumers, you want to tailor the language. And the same goes for any children that you're processing data for. Consider how the policy will be updated and communicated, and get business sign-off.